attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation in a LawCast series talking about Regulation A. A company intending to conduct a Regulation A offering must file an offering circular with and have it qualified by the SEC. The offering circular will be filed with the SEC using the EDGAR database filing system. Solicited prospective investors must be provided with the filed pre-qualified offering circular, and once qualified, investors must be provided with the final qualified offering circular. Regulation A rules provide for an access equals delivery method, whereby the offering statement can be provided via a hyperlink over the internet directly to the EDGAR database, and the same will satisfy the delivery requirements. The offering circular will be reviewed much like an S-1 registration statement and declared qualified by the SEC with an issuance of a notice of qualification. Like an S-1 process, reviewers will be assigned filings based on industry group. So far, the SEC has been true to its word that the review process will be lighter and less intensive than an S-1 process. Accordingly, the process is also quicker, averaging 2 to 3 months as opposed to 4+ months for an S-1. Companies may file certain updates and changes using a post-qualification addendum. Other more material changes, including the qualification of additional securities not originally included in the first Form 1A, will require a full post-qualification amendment and new review process and new declaration of qualification by the SEC. Some companies are eligible to submit an offering circular to the SEC on a confidential basis. In particular, only companies that have not previously sold securities under a Regulation A offering or a Securities Act registration statement may submit the offering confidentially. Confidential submissions will allow a Regulation A issuer to get the process underway while soliciting interest from investors using test the waters provisions without the negative publicity risk if it extremely alters or withdraws the offering before qualification by the SEC. The confidential filing, SEC statements, and all amendments must be publicly filed as an exhibit to the offering statement at least 15 calendar days before qualification. Confidential submissions to the SEC are completed by choosing a confidential setting on the EDGAR system. To satisfy the requirement to publicly file the previous confidential information, the company can file all prior confidential information as an exhibit to a new non-confidential filing, or it can change the setting in the EDGAR system on its prior filings from confidential to public. If a company wants to keep certain information confidential, even after the required time to make such information public, it will need to submit 2 confidential requests, one as part of the registration review process, and one prior to the confidential filings being made public. During the confidential Form 1A review process, the company should submit a request under Rule 83 in the same manner it would during a typical review of a registered offering. Once the company is required to make the prior filings public, the company would make a new request for confidential treatment under Rule 406 in the same manner as other confidential treatment requests are submitted. For a confidential treatment request under Rules 83 and 406, a company must submit a redacted version of the document via EDGAR with the appropriate legend indicating that confidential treatment has been requested. Concurrently, the company must submit a full unredacted paper version of the document to the SEC using ordinary confidential treatment procedure. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of LawCast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.